set up this program of 5 Brexit reviews, we thought the last one could actually be titled Brexit, Where Are We Now? Because there would be obviously a deal by then, and we would know where we will, but probably there'd be some questions and some doubts and some uncertainties. Well, surprise, surprise, several months have gone by and we still do not know what the Brexit deal will be, do not know if there will be a Brexit deal. The status of 4 million people living outside the country of their birth is uncertain. There is grave concern in Northern Ireland, and so there's lots and lots of questions. Now, you'll remember we were told there'll be some last-minute tricky difficulties, probably. The sorts of things we hoped would be at stake would be how seamless are the rules on animal feed or pilot licensing or inshore fisheries. What's going to be the arrangement there? What about a common rule book? What about state aid? All those questions are still uncertain. Now, we've got, despite or because of these uncertainties, we've got a number of expert speakers who are going to review the big picture and are going to review some of the details. And the first one is Professor Gray, who's the author of the superb Brexit blog. It is not comfortable reading for those who promised a smooth and amicable Brexit. Chris Gray is painfully expert in the field. After Chris Gray, there will be the Right Honourable Dominic Grieve. Now, Dominic Grieve is a very distinguished public lawyer. He has served in Parliament as Shadow Home Secretary, as chair of the Intelligence and Security Committee, and as Attorney General. He has been a very well-informed, constructive commentator and critic regarding Brexit questions. And at a time when law officers seem to have forgotten that they are supposed to deliver sound advice, even if the advice is unwelcome, the example of Dominic Grieve is, and I say fully and clearly, genuinely inspiring. After Dominic Grieve, there will be Jeremy Morgan, who'll join us from Italy. He's a QC, and he has, like myself, personal experience of the problems of the 4 million people living outside the country of their birth. And he will explain the various pieces of litigation which are pending before the European courts in Luxembourg. And there is indeed some news in that connection. And then we have a recording of an old friend, Michael Russell, the Scottish minister responsible for Brexit. He's got a hearing before the Parliament today. So he and I had to record his intervention, which, Zoom permitting, we will play for you. And then after questions, we'll have the pleasure of a summation by my old friend and mentor, David Edward. Let us start with Chris Gray. Welcome.
Okay. Alors, pour les Français, bonjour messieurs et mesdames, je suis ravi d'avoir été invité à vous parler aujourd'hui. Selon ma femme, qui est française, je parle français comme une vache espagnole. Eh bien, elle a raison. Mais au moins, les vaches espagnoles sont les vaches de l'Union européenne. Maintenant, malheureusement, je dois parler comme une vache du Brexit britannique, une vache folle peut-être. C'est-à-dire, je vais parler en anglais. Bon, alors, So I was asked to talk about Brexit. Where are we now? And I don't know where to begin, really. Maybe I should just sort of quickly say, for those who don't know me, a little bit about who I am. I've actually just retired. So I'm now actually an emeritus professor at Royal Holloway, and I was in various places before that. And as Ian mentioned, I started writing this kind of blog about Brexit as a sort of semi hobby, or was it some form of therapy? I don't know, in 2016. And amazingly, it sort of took off, and people started reading it, and it's now become almost a full-time job in retirement. And anyway, there's various nice things up on the screen there. People are saying the nicest one was last weekend, the doyen of Brexit commentators in the Irish Times. How about that? So I've actually sort of now become, yes, I think actually I've now become what is described as a Brexitologist. So I never imagined that.
A second career.
Yeah, second career, or a nail in the coffin of my career, probably. So, I mean, where are we? I mean, it's very difficult to sum that up, but I mean, one thing which I would quite like to emphasize, and which and those people who do read my blog would have read what I said about this last Friday, which is that, you know, although you sometimes see people saying, oh, you know, it always goes to the wire, and this is a typical kind of EU negotiation. I mean, that really is a misnomer, I think, for one thing, because it mistakes what perhaps is a pattern at, say, EU summits or something like that, as compared with third country negotiations. And I think the more fundamental point is that this so-called this last minute situation doesn't come out of nowhere. And actually, on the sort of the back or out of the blog, I'm actually in the process of writing a book, which is going to tell, you know, as far as one can tell it in 80,000 or so words, you know, the Brexit story. And I've been going back through the old blogs and other kinds of sources, and it's actually sort of, it's truly astounding to see how all the way through that process from June 2016, how much of it was almost entirely in terms of an internal UK domestic debate about what Brexit would actually mean, and the numbers of ways in which, through two general elections, two Conservative Party leadership contests, the way in which as soon as for those who remember that far back, you know, as soon as the phase 1 agreement of the Article 50 talks was kind of notionally completed, that within days of that, David Davis was saying, well, actually, of course, this is all not at all in any way binding, and so on. But anyway, we're into phase 2 now. Phase 2 began, and the UK policy promptly fell apart all over again in terms of a huge, long internal debate that ultimately led to the Chequers proposal and all of the things after that people will remember. And then when we got through, I mean, I'm obviously, I think I've got 10 minutes, so I'm not going to talk about the whole story. But then when we sort of get through and we have a political declaration, which at least apparently sets out a framework for the future terms negotiation, and that promptly is more or less set aside by Boris Johnson and the British government, as if it were all just some sort of piece of paper that nobody really needs to care about anymore. And things almost began again from a kind of a blank sheet almost as regards future terms in February 2020. And so the reason why we are in a time-pressured crisis is because, in one way or another, we've been in a time-pressured crisis since, well, certainly I think since the triggering of Article 50 in March 2017. So all of that, in a sense, is reaping what we have sowed, and I liken it there in the image to trying to sort of build an aeroplane whilst it's in flight. But actually thinking about it is even worse than that, because not only was this plane being built whilst in flight, but every time there was anything that was proposed to Brexiters, or what I would call the sort of the kind of Brexit ultras, and so not just people who were sort of pro-leave, but people who were really on the far extremes of that, that every time something was conceded, if you like, then there was a fresh demand for something that was even harder and even harder. So even the terminology of what we meant by soft Brexit and hard Brexit sort of came to shift, so that people still are talking about Theresa May's Brexit as sort of soft Brexit, and then therefore no deal Brexit becomes hard Brexit. And I think one way of looking at how those demands have shifted is just to imagine if the terms which are more or less on offer now for leaving the EU had been offered to British, as we used to call them, Eurosceptics, say in 2015, I think they would have jumped at them. Whereas now, some of them at least are talking about them as totally humiliating and unacceptable. So where we are is an artifact of where we've come from. The question that's on everybody's lips is, well, will there be a deal? And my view about this, you know, for a long time has been, you know, it is impossible to predict. And in a way, it's impossible, and in a way, therefore, it's actually pointless to try. And there are many people who propound, announce with great certainty, of course, the plan was always that there'd be a deal at the last minute. And there's other people with equal certainty saying, of course, the plan was always that there was going to be no deal. Well, some of those people are going to be proved right, and some of them are going to be proved wrong. But I don't think there's any. I don't think there's anything preordained in here. In this, I think, well, I say on the slide, more likely there was never an agreed plan. I don't think there was ever an agreed plan, and there's, I think, it's good reason to think that Boris Johnson, who clearly is politically the key to unlocking this, because it can't be unlocked at the level of the technical negotiators. It's a political decision. It's very possible he doesn't. He you know, even now is sort of sitting in Downing Street or wherever he is, and doesn't know which way he's going to jump. I don't think, you know, there's almost emerged. I talked about Brexitology. There's almost emerged something like a kind of Kremlinology of sort of trying to read and decode the signs of what is of what is happening. But actually, you can read those signs equally well as leading us towards a last-minute deal, or it's a triumph of negotiation, or a last-minute no deal, and accusing, you know, the EU of bad faith and so on. We know what basically needs to happen. We've heard, you know, endlessly for the last however many months, you know, about the kind of key issues about level playing field, about fish, about governance, and Ursula von der Leyen restated that this morning. I think it's interesting and a direct consequence of what's happened with the internal market bill, that the issue of governance is so much to the fore to an even greater extent than it was a few months ago, because we see these negotiations again, because of a long process and a long story, are really characterized by very, very little trust. I mean, my only other thought about will there or won't there be a deal is that I don't think it's beyond the bounds of possibility that there will and there won't be a deal. In other words, that there will be, you know, some mechanism of taking those contentious issues and doing some kind of can-kicking exercise, maybe, you know, oh well, we'll have some provisional agreement, but we'll put it in future reviews, something like that, that might perhaps mean that we still that we have a deal and yet we don't, and that we don't have a full deal, something like that. I mean, I think the important thing to say about deal or no deal is that both of these are bad outcomes, right? No deal is clearly a worse outcome, but these are neither of them are good outcomes, and certainly neither of them are anything remotely like what was promised to British Leave voters in the referendum campaign. I mean, if people recall, we were going to be inevitably in a free trade zone that stretched from Iceland to the Russian border, and so it's clearly not going to be a good outcome. But I think the more important thing to say is that whatever happens, it is not going to be the end of the negotiations between the UK and the EU about what Brexit means. Brexit is not going to be done on the 1st of January, you know, either because there are going to be all kinds of loose ends that go on being tied up for years, and indeed, you know, all kinds of, in probably quite micro areas, you know, renegotiations of certain kinds of of things that had been agreed. Or of course, if there's no deal, that isn't just, oh well, you know, we just forget about Brexit, but immediately there would be very time pressured and intense negotiations just to put in place, you know, fairly basic kinds of mitigations around what no deal would mean. And I think the other thing, going back to the idea that what has driven this process through the years is still driving it, the idea that of the impossibility of satisfying the demands of the Brexit ultras, we should recognise that if there is a deal, that some of those people will be calling it a betrayal and will do so for years. And if there is not a deal, then I think it is inevitable that the demands which have been already voiced for several months from some of, as I call them, the ultras, you know, so the kind of the John Redwoods and the Ian Duncan Smiths, there will be an intense demand to renege on the withdrawal agreement, and particularly, I think, on the financial settlement. Because I think those Brexiters have never accepted that the financial settlement was a payment for past liabilities rather than a down payment on a future trade deal. And so then my final thought about all of this, for what it's worth, is that I think that the looking ahead, the really important issue for those people who care about such things is, you know, Britain has left the EU, whatever happens in terms of the deal. And I think the key issue is to think in terms of how can we normalize that set of relations as if they were, as they should be in some sense, you know, a normal set of international relations between friendly powers. Because the difficulty is that Britain and British debate is still stuck in the rights and wrongs of Brexit, and is still entirely framed, I think, in terms of that question that has actually now been answered: should Britain be or not be a member of the European Union? And the antagonistic way in which the negotiations have often proceeded, I think, have been, you know, have always been defined by Brexit. Now, my view would be, okay, many of us didn't like it, but you know, they have won that battle. Britain has left the EU. The question now is not to allow that antagonistic frame of Brexit to characterise the future relations between the UK and the EU for potentially forevermore. So those are my opening thoughts. Thank you.
Many thanks. I had the honour of sitting with the president of the other judges when the president of the commission was sworn in earlier this year. And she said in 3 languages, very gracefully, a number of very, very commonsensical, reasonable ideas about, among other things, relations with the. It was dismaying to read how her mild-mannered and intelligent remarks were presented the next day as being something like a declaration of war. So thank you very much, Christopher. Our next speaker is Dominic Grieve.
Thank you, Ian, and thank you very much for inviting me to this colloque of the Franco-British lawyers, where we can have a think about current problems. I find myself, inevitably perhaps, having listened to Chris Gray, in agreement with, I think, everything that he's just said. So I'm conscious that I don't just want to repeat it, but perhaps give a slightly different angle of my own to some of the issues that we're having to confront. I always remember being very struck at the moment when the referendum went through, to find that the following day I had quite a few constituents who believed that we had already left the European Union. And I really think this was quite a widespread phenomenon. They had, in a sense, been sold the fundamental message that they were about to make a decision, that the decision was going to respond to some of their inner fears about the growth of a European superstate and its over-regulation. And that by voting to leave, they would, as Chris rightly said, have most of the benefits, if not all, of membership as they understood it, but somehow without any of the constraints. And of course, that is effectively what has dogged the entire internal debate of the United Kingdom ever since. Because even my Brexit supporting colleagues in the Conservative Party, who were more sophisticated and knew very well that the subject matter would then have to be debated and negotiated in order to achieve that magical end of being out of the EU, but with the advantages of membership, appeared to believe, or to have persuaded themselves, that this would be quite an easy project. And what's happened is that the project has become more and more binary, because the more it goes on, the more the concessions that have to be made to have the advantages of accessing the market or maintaining some of the advantages of membership bring about the very constraints that they objected to in the first place. And that's the reason why this entire saga has seen polarization increase and proposals put forward for a long-term relationship consistently rejected by members of the ERG in Parliament and others, and enough in number to constantly push a Conservative government in the direction of taking a harder and harder line. It's what ultimately was Theresa May's fate, and she was never able to satisfy that section of the Conservative Party. And of course, one of the problems was she fueled it, because in order to try to persuade the Conservative Party to accept her ideas, she embraced a rhetoric which was often quite hostile to the EU, the characterization indeed of Remainers and Leavers as citizens of somewhere and citizens of nowhere. But she was doing that because she was trying to escape their clutches, but she was never able to. And as we saw last year, in the summer of 2019, it eventually destroyed her politically. And we got Boris Johnson. And the difficulty is that the Prime Minister, as I think I have said on a number of occasions, is a person whose sunny, optimistic exterior masks a complete absence of any detailed policy thinking at all, apart from a deep desire to be popular and a deep desire to escape unpopularity. And the two things are not necessarily one and the same. And so his entire strategy has been, bluntly speaking, utterly dishonest, although the extent to which his own, it involves a high level of self-deception by him is something which I think only a psychologist could possibly answer the question. But we saw in the autumn of last year, it's 12 months ago, in that run-up with the extraordinary turnaround of when he was confronted by the fact that he couldn't achieve or was not being provided with the necessary power to achieve a no-deal Brexit if necessary. And I think it's worth bearing this in mind for where we are now, all the interlocutors from the civil service whom I have ever spoken to were convinced in the course of August and September of last year, in the run-up to prorogation and during the prorogation period, that there was a very high likelihood that Boris Johnson was willing to take the UK out of the EU with no deal of any kind at all. And it wasn't just a piece of window dressing on his part. And of course, when he was thwarted from doing that by the Benn Act, passed in September, he then had to find another way out. And I think it's quite characteristic of him that he found that way out by doing the deal with the Taoiseach Leo Varadkar, which effectively contained within it all the problems that have now beset the negotiation in its closing months. Because many of us pointed out at the time that whereas Theresa May, who was a unionist at her fingertips, was determined to keep the United Kingdom as an entity in some whatever future relationship with the EU was needed, which was why she ultimately went for the backstop being UK-wide, he was prepared to jettison that and in the process create circumstances in which Northern Ireland could, at least to an extent, very considerable extent, be carved economically out of the United Kingdom altogether. And I think it's also characteristic that 9 months later, he has now sought to reverse that by bringing into Parliament the Internal Markets Bill clauses on Northern Ireland, in a way which, interestingly, shows that far from having some well-laid plan, actually he's flying by the seat of his pants. Because on the face of it, it is difficult to see that this extraordinary decision to flagrantly breach international law and renege on a treaty which he'd signed only effectively 10 months beforehand, has actually done the government any good at all. On the contrary, what we've actually seen happen in Parliament is that members of the House of Commons and the House of Lords, including members who were previously fairly ardent supporters of Brexit, have parted company with the Prime Minister and stated that this is a step too far and is going to do the United Kingdom's international reputation untold damage. As a consequence of which, I think it's worth bearing in mind that unless the Prime Minister gets a deal, and I'll come back to that in a moment, but unless he gets a deal, he is not going to get the Internal Markets Bill through Parliament before the 31st of January. And he needs the Internal Markets Bill in order to preserve an internal UK market. I know Mike Russell will doubtless, when he comes to speak in a moment, highlight why the Scottish Government doesn't like the Internal Markets Bill. And I certainly acknowledge the Internal Markets Bill could have been handled differently, including for those sections concerning Scotland and Wales. But the reality is that there has to be an internal market or the United Kingdom will grind to a complete halt. And at the moment, there isn't one. And if the Prime Minister doesn't get a deal and the Lords insist on their amendments, the Internal Markets Bill will fall. And whilst I suppose it is just possible that the Prime Minister could again prorogue Parliament in the 3rd week in December to have a new Queen's speech and force an Internal Markets Bill through the House of Lords on the basis of its previous rejection in a new session of Parliament, it has all the makings of a merry constitutional crisis of a kind that Boris Johnson seems to specialise in. So there are some quite significant constitutional issues lurking around in the background. And it may be that that's one of the reasons why it is more likely than not that we will get some sort of deal which removes the sting of the Northern Ireland Protocol. Because without it, I think Boris Johnson is going to be in very serious difficulties. Clearly, I've always taken the view that he would like a deal. But he is mired in the same fantasy as those of my constituents on the day after Brexit had taken, the referendum had taken place, that you can have a deal without cost. And that then brings me to, I suppose, just briefly, 2 other points. If we don't have a deal, I agree entirely with Chris Gray. We are going to have very urgent and complex negotiations in the course of the early part of next year to get some sort of deal. I mean, the idea that the United Kingdom can safely be out of the European security arrangements, or indeed it's good for our EU partners that we should not form part of the European security arrangements. I haven't come across anybody who doesn't think that they are really important. And as I've always understood it, what is being negotiated at present is a trade and security deal, probably not much else. And I suspect more security than trade, partly because the security angle certainly suits the EU as much as it suits us. Whereas the trade deal, I think we are at a significant disadvantage, even though they want it themselves. The other issue, and I think and that brings me really to my last point, is what's this doing to the UK's international standing outside of the EU? Because of COVID, much of this has been masked. But the interesting thing is that my Brexit supporting colleagues undoubtedly supported Brexit in part because they believed passionately that it was going to give the United Kingdom a degree of freedom on the international stage, which it couldn't enjoy while it was a member, including doing these magical trade deals with third countries, but also enhancing British influence and power in a variety of ways. And yet look where we are. We now have an American president-elect who is perfectly sympathetic to the EU, and I don't think very sympathetic to the United Kingdom, although I have no doubt that our security cooperation will continue because we're one of the USA's key partners. But what I think I found most interesting in my role as chair of the Intelligence and Security Committee, even in the run-up to my departure at the end of last year, is that during 2019, lots of other countries that have security relationships with the UK, particularly in the Middle East, who really hadn't paid any attention to Brexit, started to wake up and say, what on earth is going on? This all looks very chaotic. What's happened to the United Kingdom? And the overall picture, which I picked up and I've continued to pick up since, is one of utter bemusement and a sudden realization that the UK is in the middle of an identity crisis, which looks as if it's going to have serious repercussions on our worldwide global reach. So what's going to happen? I don't know what's going to happen in the next 3 weeks. What I am convinced of is that the Prime Minister has a very big problem, because although there are many members of the Conservative Party and indeed parliamentarians who may have been perfectly happy to go along with Brexit will now claim they embrace it, the picture of a United Kingdom which is poorly performing economically, cutting its overseas aid budget, because I think that's what we're about to do when Rishi Sunak stands up at midday today, or 12:30 actually after PMQs, is showing signs of diminishing influence on the international stage. And on top of that, has its own internal crisis about the future of the Union, and a Prime Minister who over COVID has been shown to be utterly inadequate in his response, and indeed to be presiding over chaotic government. All these things, I think, don't offer a good prospect for the Prime Minister in the 12 months to come. So it may be that we will end up with a new Prime Minister, and perhaps the reset which Chris Gray seeks, and where I agree with him, is very badly needed if we are to go forward. But it is a rather strange situation, and it just seems to me to have coloured the entirety of this Brexit saga, that there's a terrible sense that you've got to get to zero before you have any chance of rebuilding the obviously needed relationships with our closest neighbours. Thank you.
Thank you very much. That was not comfortable listening, and it's almost tragic to say, by way of comment, that nothing that you say so eloquently is surprising. It is extraordinary that so many people have been saying less elegantly or well-informedly than you have just done exactly the same points, and that is a very sad situation. Now, we're going to hear from Jeremy Morgan QC, who is in the thick of the litigations regarding the status of individuals. Jeremy.
Thank you, Ian. And I'm not going to attempt French like Chris, because an Italian cow would probably speak even worse. I should start with an apology when talking about cases in the European courts. I'm not a Euro lawyer. In practice at the bar, the closest I came to Euro law was to appear in, I think it was Factor Tame number 10 as junior counsel. Factor Tame, of course, was all about fish. It was the longest running of the Euro sagas. But the case I appeared in was more to do with the English law and contingency fees. However, as Vice Chair of British in Europe, I've had to have a crash course in EU law and have come to know something of the subject. A word briefly about British in Europe, because it's at the heart of what I'm going to say. British in Europe was formed early in 2017 as a coalition, literally a coalescing of 10 groups of UK citizens living in various EU states who got together to protect their rights as EU citizens. I should say that there was a big pressure on us from very early on to sue. Litigation was seen by many as a panacea for all ills. Fortunately, we had 3 lawyers on our steering committee, and the experience of 3 lawyers dictated that going to court is a dangerous exercise, and in an uncertain legal environment, far better to negotiate first and only sue when you have no alternative. So we focused on lobbying, producing detailed legal analysis, getting both sides to recognize the importance of citizens' rights and the legal issues that had to be solved. The other reason we didn't sue was because of the rules which apply to public law litigation, I think, in all countries, and particularly in the EU General Court. Firstly, you have to identify some act or decision that you want to challenge. If you go too early, before that act is definite and with legal effect, you're going to be rejected as having moved prematurely. And if you go too late and the time limits are inevitably short, you're out of time. So litigation at that stage was very, very difficult. But we have, as you will hear, applied to intervene in 2 of the ongoing cases. And I should say we are very fortunate to have an exceptionally strong legal team which has agreed to act for us pro bono. That is the Brussels office of White and Case, led by Sir Nicholas Forward QC, a retired judge of the General Court himself, and an exceptionally strong leader for our team. And we are very, very grateful to them. You might say, well, why should there be any cases anyway? Because surely the withdrawal agreement has given British citizens affected by Brexit all the rights they should have. The clear answer to that is no, it has not. The biggest loss, there have been a number of losses, but the biggest loss is that of freedom of movement. It's quite hard for those of you who are listening from the UK who haven't been outside the UK other than on holiday, perhaps to appreciate the true importance that the lack of barriers caused by EU borders has to those who work or provide services in the EU. The erection of those borders for UK citizens now has caused massive problems to people who've made a life and a career on the ability to provide services or to work across the EU countries. For example, IT contractors working on short-term contracts who move from one country to another as the work dictates, or others providing services such as caterers or performers or any number of other jobs that you can think of where it's necessary to be able to move from one country to another without visas. Imagine a builder based in Manchester suddenly being unable to get a job in London, or a performer from Yorkshire having to get a visa to do a gig in Cardiff. Those are the sort of barriers that have now been erected, and the fact that they're still there despite the withdrawal agreement is probably the main reason why we have been contemplating litigation. What then are the arguments for redress, the legal arguments? At the heart of any of these claims is the concept of EU citizenship. The point was well put by Professor Eleanor Spaventa in an article inquiring whether at the stroke of 11 p.m. UK time on January the 31st this year, UK citizens in the EU remained as horses, as in the horses drawing Cinderella's coach, or as mice, as when the horses revert to their previous state. She said, Brexit will put the very concept of union citizenship to the test because, after all, what is the value of a status which can be erased literally at the stroke of a pen? Not much of the argument in the cases proceeding in the EU courts just now is in the public domain, but there seem to be 3 main strands. All proceed on the footing that it is wrong to say that all the EU citizenship rights of all British nationals came to an end automatically on January the 31st or say December the 31st this year. The first argument, which I call the fundamental status argument, is this. EU citizenship has been said in the cases, and the strong authority for this, to be the fundamental status of nationals of member states. It is a personal right of the citizen and conferred directly by EU law. Once vested, it does not automatically demise upon the withdrawal of the member state of nationality, so goes the argument. It cannot be removed arbitrarily without the consent of the citizen and without due process. It's the broadest formulation of these arguments, and it will protect the rights not just of UK citizens in the EU, but also of UK citizens in the UK, that's to say the citizenship rights. The second argument, which I call the legitimate expectation argument as a shorthand, is this. UK citizens who had properly exercised their EU citizenship right of free movement while the UK was still in the EU had a legitimate expectation that their EU citizenship rights would not be removed And having acted in reliance upon that expectation, these rights cannot now be removed. That would protect the rights of UK citizens living and working in the European Union. The third argument is a slight variation. EU citizenship cannot be removed without a specific assessment of the consequences of doing so and the application of a test of proportionality, so well loved in EU law. This would protect the rights of those for whom their removal would be disproportionate. The proportionality argument is what I shall describe it as. It could be used to claim protection either for specific classes of UK citizens, such as UK citizens in the EU or subclasses of those, or on an individual basis to argue, for example, that before a state refuses to admit a UK citizen under freedom of movement, it has to apply a proportionality test. And there's a fourth argument, which I haven't seen spelled out in the cases, but which has been set out in an interesting article by Elena Spaventa, and that is this, that EU law should recognize a new category of citizens in the EU, that of former EU citizens. She uses the analogy of third country national family members whose link with an EU citizen is lost by death or divorce, but they still retain their rights. And she argues that the status of those EU citizens who lose their link with the EU, not by divorce from a person, but by the divorce of their country, should be no worse. Building upon the fundamental status of EU citizenship, she argues that it would be wrong to apply a strict black letter law approach to their residence rights. So before removing residence rights from UK citizens in the EU who don't perhaps meet the strict criteria of the withdrawal agreement or the freedom of movement directive, member states should apply a test of proportionality based on the fact that until Brexit, these people were EU citizens. Those are the four principal arguments that I think are being deployed in the cases. And I'd like to turn them briefly to the cases where they are and what they're claiming. I should add at the outset, I'm not going to comment on the merits of these cases. I don't want to get drawn into a discussion of the merits. It seems to me that the merits should be argued in court, and it doesn't help to have even, even high academic webinars such as this commenting on the merits, still less social media. I should say at the outset, there have been a number of cases brought both during the negotiation period and the transition period, challenging the effect of Brexit on citizens' rights. The most admirably energetic lawyer has been a Frenchman, Maître Fouché, an avocat from Bordeaux. Most of his cases, I'm not going to go into them now because there isn't time, most of his cases have fallen foul of the rules on standing in the General Court, or have been dismissed because the creativity required to get around the rules on timing and standing simply went too far. But I will look at the cases which are current now. As far as I know, there are 4 of them, 3 in the General Court and 1 on referral from the National Court. Taking them in date order, in the General Court, the first case that was started was Schindler and the Council, started in March 2020 by Maître Fouché. The case claims annulment of the Council decision approving the withdrawal agreement, either wholly or in part, insofar as it distinguishes automatically and generally, without any test of proportionality, between EU citizens and UK citizens from the 1st of February 2020. So you'll see immediately this is a proportionality argument, but claiming that because of lack of proportionality, the whole Council decision, or at least significant parts of it, should be annulled. There are 13 detailed pleas in support of the claim, which I shan't spell out. They're very wide-ranging. They range from the fact that the British didn't vote to leave Euratom to ones of more immediate interest on citizens' rights. The first being that Article 127 of the withdrawal agreement discriminates unlawfully between British and non-British citizens. Article 127, I should explain, is the article which introduces the transition period and kicked in on the 1st of February this year. And although we in Europe retained most of our EU citizenship rights, we were not allowed for this transition period our right to vote or stand in EU and municipal elections. In particular in France, there were people who complained about not being allowed to stand in or vote in the French municipal elections of the spring of this year. And the second issue which he raises in support of this general claim is that the withdrawal agreement removes EU citizenship from UK nationals automatically, and a specific proportionality assessment should have been carried out. This is the first of the cases in which the British in Europe has applied to intervene. The details of the intervention are still, I'm afraid, confidential. The council, the defendant to the case, lodged an objection to the admissibility of the case as a whole, I assume principally on standing grounds, and the grounds for standing in the General Court are, as I've said, extremely restrictive and hard to get round. That had the immediate effect of staying our application to intervene, but the court has recently decided that it will hear both admissibility and merits at the same time, so the case will proceed to a full hearing sometime next year. The next case, another one of Maître Fouché, started in April 2020. It's Price and the council, and this claims partial annulment of the decision of the council to approve the withdrawal agreement and the annulment of parts of the withdrawal agreement itself. But what's most interesting about it to me is that it seeks referral from the General Court to the Court of Justice of 4 questions, of which we shall hear more later. They're in this order. Does the withdrawal of the UK from the EU revoke the EU citizenship rights of UK citizens in the EU? So is there an automatic revocation as a result of Article 50? If so, this is the second question, if so, are these rights retained by a combination of the provisions in the withdrawal agreement and of the Treaty on the Function of the European Union, especially Articles 18, which prohibits discrimination, 20, which establishes EU citizenship, and 21, which established freedom of movement. Thirdly, if those rights aren't retained by the withdrawal agreement, does the withdrawal agreement breach Articles 18, 20, and 21 of the TFEU? And finally, in any case, does not Article 127 of the withdrawal agreement, the voting rights provision I've discussed already, not infringe Articles 18, 20, and 21 TFEU and the provisions of the Charter on Voting Rights? An application was made by Maître Fouché for interim measures to suspend in part the decision of the Council approving the withdrawal agreement. That was heard in June. It was rejected largely on the basis the action was inadmissible because of the restrictive standing rules in the General Court. An appeal was lodged in July and has yet to be heard by the Court of Justice. The third case I want to mention, and this is the one which is not started by Maître Fouché, is Silva and the Council. It started in April 2020, and it's brought by claimants mainly resident in the UK, but one of them is resident in the EU. The firm behind it is DAC Beechcroft in London, with Takis Tridimas, well-known EU lawyer, as their counsel. The claim is that the Council decision approving the withdrawal agreement should be annulled insofar as it deprives the applicants without their consent and without due process of their status as EU citizens and the rights arising therefrom. It puts the fundamental status argument fairly and squarely. Indeed, I've taken my description of that argument from the details which are on the Curia website about the claim. BIE has applied to intervene in this case as well. As with the Schindler case, it was initially stayed because of an objection by the Council to admissibility, but it's likely that the court will order admissibility and merits to be heard together, as the same court, the same division, has already done in Schindler. The reason for the difference in timing is that Schindler was started a little bit earlier than Silva. Those are the General Court cases. The fourth case is something of a mystery. All we know about it is from a recent announcement on Twitter by Maître Fouché that he's got a national court to refer to the CJEU the 4 questions he raised in Price. Those are the 4 I read out earlier. It's slightly surprising because in October, the French Cour de Cassation had refused to make such a referral. So which court in which country has made the referral is not yet clear. It will be very interesting to see how the 2 levels of EU court deal with these closely related cases, but one way or another, it seems that the CJU will have to decide that most fundamental of all issues. What does it mean to be an EU citizen? Thank you.
Thank you very much. I've been reading the chat and questions and answers, and I see one lady, Alice, who says, my case has just been referred to the CJUE, and another person who says, please can we bring back John Major as our next Prime Minister? I think that's beyond the remit of this society. There's lots of questions that people will have, but I think maybe we should now switch focus a little bit. And before doing questions for yourself and Dominic, let's hear from Michael Russell and ask of the society if you will now press play on. Mute. Embarrassing, I'm sorry. It's my own fault. We're not hearing any sound. That sounded like
a great
sound.
pleasure to have with us, although only virtually with us, Michael Russell. He's a minister in the Scottish Government, and he has been an extremely interesting voice in the discussions about Brexit over the past 4 years now. And I well recollect the first time that we met was on an official visit by the General Court of the European Union to Scotland. And Michael Russell described his constituency and its need of immigrants and other matters extremely pertinent to the Brexit debate. So he was to have been here today, this very day, but a parliamentary hearing got in his way. So we have recorded a day or two ago what he had to say. Michael, you're most welcome.
Thank you very much, Ian, and thank you for inviting me again, and my apologies for not being able to do this on the day, because I have to take through a bill in the Scottish Parliament which is very germane to the issue of Brexit. I might start there. The Scottish Parliament is in the process of passing legislation that will allow us to keep pace with a variety of European regulation. And I think people in this gathering should take that as a sign that Scotland wants to be in the EU, and now we're not in the EU, is looking forward to the day when we can rejoin the EU as an independent state. And in passing, I'm sure people will want to note that the opinion polls in Scotland indicate a majority support for that position at the present moment in time, and have done during this year. And I hope we are in the process of change towards independence, a referendum on independence, and then to rejoin the EU. And that will be nothing exceptional. And I want to make that clear. I don't regard that as abnormal or a matter of enormous excitement. Maybe I'm inured to it by now. It seems to be the normal progression for a small nation, which faced a European nation, faced with a choice of whether it departs from the mainstream or remains in the mainstream, whether it collaborates or it creates a completely false image of itself as some way a global power. Then I think the choice is very clear for the people of Scotland, and the vast majority of people of Scotland know the right choice to make. But I'm talking and recording this when I don't know what the outcome will be of the negotiations in the UK and the EU. It may well be when you're watching this. We still don't know. Every Monday morning, I get up and think this will be the crucial week in the end game of these negotiations. And when it gets to Friday afternoon and we've had the ritual press conferences from the two negotiators, we think, well, maybe next week will be the important week. But I don't think that should detract us from considering what is likely to happen and what the end of this year and next year will look like, and the problems it will pose. And then I want to say a word or two about how we resolve those problems. We are now in the end game of this process. The end game of this process is interesting in terms of democratic will, because I noticed earlier this week from an opinion poll that not a single part of the UK now in the majority believe that Brexit was a good idea. So we're moving towards a cliff edge, but nobody actually thinks it's a particularly good idea to go there. But nonetheless, the UK is going there and it is dragging Scotland along behind us. Behind it. So what we have to do is to say, what will that cliff edge look like? What are we looking at when we look over the cliff? And we're looking at a fairly dismal prospect. Either looking at a no deal, although there is no such thing, and I'll come to that in a moment, or what I have called a low deal. And both of them are quite similar. And indeed, even the UK government admits the difference between the two of them is not great. On a no deal, the UK has used the term trading under Australian rules or the Australian model. In actual fact, it is the Somalian model. It is the Rwandan model. It is a model much more than the Australian model in which there is no fixed or formal link with the EU. And indeed, everything is, as a third party, there is no formal arrangement. I don't think that is tenable. I don't think for any state that's actually literally on the edge of the EU, that is something that can last. And I think in the end, there has to be a deal of some sort, particularly given the integration of the economies. So what a no deal is the postponement of an inevitable set of arrangements, which as time passes will be poorer and poorer. Arrangements will be worse and worse in terms of the offer that exists. Or a deal that is reached which accepts, and has to accept, because this is a reality, that the UK is a third country, but that there will be a free trade arrangement between that third country and the EU. And the question is how beneficial that is for both parties. And the answer at the present moment is that what the UK has been asking for isn't beneficial at all. When this process started 4.5 years ago, and during the EU referendum in 2016, there was an assumption virtually across the political spectrum that the outcome would be an outcome of continued membership of the single market and the customs union, and perhaps not of the customs union, but certainly of the single market. That has not happened. And indeed, that was ruled out not at the beginning, but as late as the Mansion House speech that Theresa May made in February, I think, 2017. And since then, those who are on the extreme edge of this argument, who have a vision of the UK, of a global Britain, a vision that never is not based on any past reality, but they believe it is the destiny of the UK to have that sort of position, that they are the people who are in the ascendant. And politically, what has also happened is that Boris Johnson, in pursuit of becoming Prime Minister, has been able to reshape the Conservative Party in that image. So you have a substantial majority in the UK House of Commons, not in Scotland, where the Tories are a minority party and have actually not won an election since 1955, when I was 2 years old. And I think you can look at me and think I'm considerably older than that now. But in the UK, that party has been reshaped in order to provide a majority for what is a fantasy position. But it's a dangerous fantasy, because what it's doing is it's pushing the UK into severe financial difficulties. And that is, unfortunately, where we will find ourselves. So what Scotland is faced with is a choice. Scotland did not vote for leaving the EU. Scotland has seen the consequences of leaving the EU, and there's been a great deal of work done. The Scottish government has published extensively on it, but so have many others. And Scotland has, I think, said we need to come to a decision, and we need to come to a decision fairly soon. The insecurity of this is very damaging. I mean, inter alia, just imagine if you were in a situation, because we are in this situation in the UK, where the major dislocation that we know will take place is less than 40 working days away, but we actually don't have any indication of precisely how severe that will be, or precisely what we will be doing, for example, at the borders. There isn't any such information. And indeed, so sketchy as are the preparations that there will be essentially no border controls, import controls for most of the first 6 months, even on the present UK government plans, and possibly for considerably longer than that. So Scotland is in a position where it will have to make a choice. Now, the people of Scotland know that. I don't think anybody is that surprised by it. There's a very hardcore of people who regard that choice as unacceptable, who wish things to continue as they are. There are some who wish things to go backwards, including the Prime Minister, who very recently described devolution, usually described as the settled will of the Scottish people, a mature change in the Constitution that took place 20-something years ago, not terribly radical, as being, in his words, a disaster. And indeed describing it as the worst disaster that Tony Blair had brought about, which is worth thinking about if you think of Tony Blair's role in the Iraq War, that according to the UK Prime Minister, devolution, giving people a vote, having power closer to people, subsidiarity, is a bigger disaster than the Iraq War. It does say something about the Prime Minister's mental state and the way in which he looks at the world, which is very worrying. So Scotland, I think, will make that choice. I think we have a procedure to allow that choice to be made. The UK Constitution is complex, and the decision of the Scottish Parliament to have a referendum is not binding. It requires also for the Westminster Parliament to agree to that as well. It has not done so, and Johnson wishes it not to do so. And as Johnson has such a majority, that has prevailed up until now. But the present Scottish government it will have this as a main platform in the election next year. We anticipate that if we are successful, we will pass a bill to do this very quickly, and then we will get on and give people of Scotland that choice. And I think they will choose to be independent within the EU. And that will also allow us to define our relationship, and this is a final point I would make, Ian, to define our relationship with the rest of the UK and what is left of the UK by means of our membership of the EU. And that is very important, because there will be, as we've seen with Ireland, a solidarity in that that would not exist otherwise. Now, in the brief 8 or 9 minutes that I've been speaking, I haven't mentioned the other issues that crowd around, because Brexit is a major threat for the rest of this year. But then COVID is still with us, and it's a very serious situation for all of us. And we will also have to work with the concurrent winter pressures that happen in any health service. So I think I can say, regrettably, that this is going to be a very difficult winter for all of us, wherever we are, but particularly difficult in Scotland and in the UK. And it's up to politicians not just to say that, but to work to try to mitigate that, which we will be doing, but also to have an optimism. And I finish on the note of optimism. I haven't wanted to do this for the last 4.5 years. It's been one of the hardest jobs of my life. Negotiating with the UK government is, I think, as Mr. Barnier has found, not exactly a pleasure. But I do think that it has crystallised the issues. And I think in crystallising the issues has made the choice crystal clear, which perhaps it wasn't as clear in the independence referendum in 2014. I think people now know there is no status quo. It is about where Scotland should sit and how it should reshape itself and rebuild itself after the pandemic in the modern world. And I have no doubt, and I think many of my fellow citizens have no doubt, that that lies within independent membership of the EU as a small mainstream European state. I hope that's of interest.
Many, many thanks. Oops, right. Let me ask 1 or 2 questions. First of all is an emotional one. I am so old that I remember the Stirling, west of Scotland, your constituency, and big halls and courteous, passionate discussion, and I emphasize courteous. By contrast, the 2014 referendum on Scottish independence and the 2016 Brexit referendum were poisonously confrontational, and they were really, really painful for those who participated, those who read the papers and so on. Yet another, my question is this worth the pain that's to be apprehended in having another referendum on such a divisive subject?
But I hate disagreeing at an early stage in these discussions, but let me disagree with your memory. I think it's a bit like we always imagine the summers we lived through as children to be full of sunshine. And in fact, there must have been rain, without a doubt. I don't have the same memory of those events in the way you have. I think the 75 referendum was, of course, in a slightly different political era where it was less confrontational. But you only have to bring to mind the contribution of a man who was an absolute great, but who, politics disagreed with him, George MacLeod of Funerary, who described, the EU as essentially a popish plot. That wasn't the type of civilized debate, and you can go look up the cuttings and see how intense that was, and you can see the effect it had, for example, on the vote in the Western Isles. The Western Isles and Shetland were the only two areas that voted against in that referendum. My memory of the 2014 independence referendum was entirely different. I think it was an energizing event. I was at that time the Cabinet Secretary for Education. I did a lot of school and university events. I also set myself the task of speaking in every village hall in my constituency in Argyll and Bute, which is a big constituency and there are lots of village halls, I have to say. I got most of them. And I remember that with enormous fondness. It was a really vital time, and the down we felt when we didn't win was a real problem. 2016 debate was, of course, the whole thing was driven by discontent and fantasy from a rather strange group of people who we now see their closest soulmates were people in a very extreme American administration, a former administration, or will be a former administration on the 20th of January. Well, let us hope so. Let us hope so. I think that's the reality of democracy. So I disagree with that. But then I also think that, yes, a democratic choice is not only worth the while, it is inevitable. If you were to say, let us not have a democratic choice because it could be too upsetting, you are setting aside the nature of democracy. It is incumbent upon us to do it in the most positive and constructive way possible. Now, social media is a bit of a problem in that. The way in which we address each other now these days is a bit of a problem in that. But I'm a politician, so I'm as guilty as many of I have to judge myself and police myself in these matters. But I don't believe that in the country of the mind, particularly in Scotland, I don't believe that we should be incapable of having a rational and productive and reasonable discussion of these matters. And as they say in Scotland, am I hoping that that's going to happen?
All right, so let's put aside emotion and talk about some practicalities. I think a lot of people.
Now, the questions went on, and they're interesting questions. And what we'll do is we will put the recording of two grey-haired Scottish men talking to each other into the bigger recording. But I think we should now get on to the questions to the speakers who are with us. And to those who are listening or watching, there's a chat function and there's a Q&A function. You've been using both. I think the Q&A function is probably the better one to go for. Down at the bottom of the screen, click on more and you'll find. Now, there is Madame Bouillet, who is here, and she's already put a question, and I see that Dominic Grieve is getting an answer, perhaps. But what she and several others are saying is, can we guess, and I guess this is to Jeremy, can we guess how likely it is that the Brits in the EU, in the 27, like you and me, will get to keep freedom of movement rights following the upcoming court cases? Jeremy, you need to unmute yourself.
Just unmuting myself, yes. I think the answer is I wouldn't really want to speculate upon it. It's there, it's claimed in the 4 cases that I mentioned, one way or another. But the outcome is very hard to predict. As I say, I didn't want really to get drawn into the merits of this discussion, simply because I don't think it helps.
Yes.
I wish all the cases well. We'd love to be successful, but one can say, you know, wonderful rosy things about, yes, of course we're going to win, and someone will say, well, there's a few problems here, and there are some problems, there's no doubt about it. Better, I think, to leave it to the lawyers to argue in court.
Mm-hmm. Maybe when it comes to the summation, David Edward has, in his time on the court, seen what you might call political cases, and I think he's not going to give a prediction, but he might mention some of the conflicting anxieties on the part of the judges in the case, because it is frequent that people facing national or other problems will invoke European law as a solution, and sometimes it works and sometimes. Dominic, did you want to intervene?
I must say, I wouldn't want to predict the outcome. I mean, logically, I'm afraid, I think the outcome is likely to be against the applicants, because these were rights which were conferred by the treaty relationship between the United Kingdom and its EU partners in being participant. You would have to succeed, you're going to have to establish that by virtue, I mean, I thought the best point may well be the legitimate expectation, because there's no doubt lots of people who've had a perfectly legitimate expectation and would have organised their lives differently and wouldn't have gone to live in a European country if they had thought that it would eventually lead to their, admittedly they can stay in that country, but that the freedom of movement, which is such an essential part of the EU as a concept, was going to disappear. I should be fascinated to see how the Court of Justice of the European Union deals with this. But it's one of those sort of interesting and rather fundamental issues. And it's also difficult to see how EU citizens in the United Kingdom are going to be able to assert, or indeed UK nationals, that they have EU citizens' rights, notwithstanding our having left. Although the details of that last case are not quite clear, as Jeremy's explained, it's not quite clear what it is that's being sought and by whom. But it will be a very, very interesting issue. But on the face of it, it's going to be quite an uphill task.
Yeah. Then there's a number of other questions on free movement of persons, and I'm afraid they're all inviting us to speculate or predict what's going to be the outcome and how useful they will be. Distinguish, please, those who are not Euro lawyers, distinguish between the General Court, which is a court for appeals against actions by European institutions on the grounds of illegality. That's to say, legality, judicial review, not was it a good choice or a bad choice, but was it an unlawful act? And that's one obstacle at the General Court level. The other is the General Court takes cases which are of direct and individual concern. And direct and individual concern has been interpreted over the years in a quite manner, despite suggestions that it ought to be widened. By contrast, references from national courts to the Court of Justice are invitations to that court to give guidance to the national court on bigger or smaller questions of law. And so the standing issue, unless it's a hypothetical question, is easier before the court. But nonetheless, these are very sensitive matters. In the Whiteman cases, that the court was willing to take a position, even in political. Now, let's move the topic. There are two different questions. I guess this is for Chris Gray or for Dominic. Does Biden's election transform the situation? Because the Biden view of global America isn't any longer parallel to the notion of the global UK that Boris Johnson favours. Dominic?
It's very difficult to answer. I mean, firstly, as I think I tried to hint in my own comments, there is an established and very close relationship between the United States and the United Kingdom, particularly at a security partnership level, which isn't affected by who's president. And I have absolutely no doubt that that will continue. That's the reason why Biden, at the end of the day, I know he rang the Irish Taoiseach first, but he then rang Boris Johnson before speaking to anybody else, because it is an extremely important partnership. And I don't see any risk of that being endangered any more than it was endangered by Trump's presidency. The difficulty is that Boris Johnson clearly saw in Trump an individual whose hostility to the European Union, which was a very marked characteristic of Trump, was likely to make him sympathetic to anything which showed that the United Kingdom's departure from the EU could be classified as a success. And so Boris Johnson had undoubted expectations that this would help in the US-UK trade negotiations. I think that may have been an exaggerated belief, but I think it is an underlying belief which was probably reasonable, in that when it came to the crunch, Trump would like to be able to show up the EU as failed and the UK as being successful outside. Biden's arrival removes that completely. I think the United States is going to pursue a perfectly measured policy, and I think the chances as a consequence of our getting a US-UK trade deal are very low, not because of something about Biden, but because in truth they've always been very low for a whole series of issues around both US protectionism and the United States' different regulatory standards.
A different question, though we've mentioned it briefly, from Simon Horsington. What about, what are the chances, and this is again a speculation, with respect to security agreements between the UK, France, the EU, add that every 2 years the Society organises absolutely fascinating face-to-face in happy times session between the British and the French navies, and we talk about cooperation on drugs, refugees, safety, pollution at sea, and so on. So those occasions where officers, young and old, in the two navies get together to discuss, and the Garde Républicaine plays Light Airs from Gilbert and Sullivan, those are spectacular reminders of how much security is important to France and the UK. The question is, obviously it would be crazy to ditch that. What are the chances that we're not going to ditch it? Chris first.
Can I just jump back to the previous bit and then come on to
Sure.
that bit, which is, and I completely agree with what Dominic Grieve said, but there's also a kind of a thing here which is a bit more, which is a level beneath or more diffuse, if you like, than the institutional stuff, which is that I think that ideologically the Trump's election, it was almost like the Brexit had been kind of John the Baptist to Trump's kind of arrival of kind of birth of Christ. And I think that if you recall what was then sort of put on that as what it meant for Brexit, having kind of caught a tide of history, that there's now very much the opposite feeling, and a kind of a sense of Brexit almost being left now as the last sort of bit of a kind of rather ghastly failed experiment that's kind of beached on the mud flats, if you like. And then the issue of the US kind of trade deal was a kind of, again, was a kind of a symbolic thing, because everyone understands that the economic value of any such trade deal would be nugatory, really, compared with compared with certainly with the loss of single market membership. But I think the other thing is which kind of, I guess echoes what Dominic Grieve said, is that they always overestimated what Trump would do for them, because, and actually, you know, he as with many things, he blew hot and cold in his rhetoric, and certainly his administration blew hot and cold in the rhetoric of whether they would do a deal. And underneath that, the kinds of asks that the US trade negotiators would have is relatively independent of administration. The kinds of things that a Biden administration will seek from a trader with the UK will be not at all dissimilar to what would have been the case with Trump, or previously in a different context, some of the asks of the Obama trade team in relation to their trade negotiations. And it's quite an important reminder that, and it's the same with the security thing. Again, Dominic Grieve would know much more about this than I do, but from a kind of previous life, I know a little bit about it. And the extent to which it is mediated by quite long-term relationships between officials, including, I think, mediated at the level of a lot of very enduring personal contacts, which are often really kind of important. And so one can kind of overestimate, in some ways, the significance of institutionally, the significance of the shift from Trump to Biden, even though ideologically or ideationally, I think is important. But then bringing to the issue of cooperation with France or with the EU on security grounds, I think the important thing to understand, my understanding of this, is that precisely because of the nature of the EU and the more rule-based kind of nature of it, that security cooperation is much more embedded procedurally and institutionally, whereas the relationship with the security relationship with the US is those things too, certainly institutionally, but also mediated by these very sort of deep and long-standing contacts. And it's much more difficult, given that despite what Brexit has said, the member states of the EU remain sovereign states. It's much more difficult to conduct a security relationship out with the institutional and regulatory, and in particular data management relationships that obtain with respect to EU security, EU-UK security cooperation. Does that make sense?
It do make sense. Now, there's a question I don't know the answer, but someone may, from a Brit. He asks, have any EU27 citizens living in the UK brought proceedings in the UK equivalent to those brought on behalf of Brits outside the UK? In other words, are the litigations which Jeremy has been describing to us paralleled, so far as we know, by cases on behalf of Brits in the UK, or sorry, Europeans in the UK?
Shall I answer that?
Please.
There is some limited litigation, but nothing at the level of the sort of claims that we're making, for two reasons, I suppose. Firstly, EU citizens in the UK haven't lost their EU citizenship rights. They retain them. The problems they have are purely in relation to the UK, rather than as a result of their withdrawal from the EU and their loss of EU citizenship. And secondly, because they'd have to frame claims quite carefully in order for the Court of Justice to have any jurisdiction over them at all. Basically, the issues that EU citizens in the UK have are ones which will have to be determined by the UK courts.
Yes, indeed, and I think the way in which that contention would arise would be if the Polish child living in Edinburgh were refused an education grant for some purposes on grounds that she found unacceptable. There's certainly the possibility of a challenge to how the UK is implementing its obligations to EU27 people in the UK.
Well, that would certainly be possible, but it would be based on implementation of the withdrawal agreement, so which is, yes, of course, part of UK law. So that wouldn't be problematic. It's saying if there's something that's not expressly provided for in the withdrawal agreement, can we have those rights? That's, if you like, where the UK litigation in the EU is going. And that
Yes.
would be much more difficult in the UK.
Yes. Then one question, I think the answer is no, but let me ask the expert, Dominic Grieve. Do you think a Brexit transition period extension is possible or likely?
I think it's most unlikely. The only circumstances in which I can see it happening would be if actually a deal is reached on the 23rd of December or even the 27th of December. There is clearly a deal, but its implementation is impossible, and therefore there needs to be an extension to prevent there being a gap. That is the only circumstances. The idea that Boris Johnson could survive having to go cap in hand and saying, could I have a 6-month extension for continuing negotiation? It's just not credible, and it won't happen. So I can just see some transition extension being brokered at the very last minute if it is then enables the deal to be implemented without there being a hole in between.
And then, well, there's a question, or there are observations from Jean-Noël Cobet. Et il nous a dit en plusieurs communications, il estime que la Cour va tenir compte de ce que, lorsque l'accord de retraite a été signé, le Royaume-Uni était toujours membre de l'Union. Donc, pour lui, les traités sont donc applicables à l'accord et d'après cette optique, les obligations du Royaume-Uni doivent être examinées. Une bonne observation. Voyons si ça correspond à l'avenir. Et Monsieur Cobet-Iltou, il a proposé diverses autres questions sur l'interprétation, enfin, sur les arguments en jeu. Et je crois que, effectivement, ce sont des bons arguments si vous êtes perturbé par Brexit comme phénomène, mais c'est facile à citer des telles questions, mais je crois que c'est prudent de proposer des points. Et puis, oui, donc, il pose pas les questions, il soumet des arguments intéressants. And then we have a question which, there are two more questions. One is, who wants to answer this? Is there anything we can do to salvage the worst case scenario that seems to be unfolding? The speakers are very gloomy. So we're citizens, we're voters, we're intelligent lovers of animals, we are articulate. What can we do to stop disaster?
Well,
Former Attorney General will tell us.
What we could do, well, the best way of stopping disaster is that out there are a large number of parliamentarians who, most of whom are not crazy at all. Particularly, I mean, I'm talking about my Conservative colleagues. I know they're a mixed bag, and there's a new group of 100 who've come in who I don't know. But the remainder, even if they're Brexit supporters, for the most part, there is maybe a hard core of people who are ideologically very committed to a hard form of Brexit, have reason to be really troubled by this. And so the message I keep on saying to people is you should be lobbying them if you're living in their constituencies, and you should be getting your local businesses to lobby them. The trouble is COVID has distracted people from focusing on just about the enormity of the crisis that we are now facing. And that is greatly to Boris Johnson's advantage, because it means that people aren't paying attention to what's going on, and this will suddenly come back in a very big way in the second week in December. But most of these Conservative MPs want a sensible deal of some sort. Some of them are in government. They want a sensible deal of some sort. So we mustn't despair. And as I said, the worst case is that we leave without a deal, in which case my strong belief is that we will have some deals by the time we get to Easter. But the intervening period will be very bad. And as I say, it will also accelerate the chaotic nature of our national politics.
Indeed, I think what you've just said is the best prediction of the future. A miniature deal which will be pronounced as a great triumph on New Year's Eve at 12:15. Wonderful triumph, the EU has surrendered. And then it'll be discovered that there are umpteen separate questions which have to be addressed, which have not been addressed. And little by little during the 9 months of 2021, one agreement. Very, very important. I think that there was also a question about the Vienna Convention. Sorry, that's a question for Chris Gray. During the Leave campaign, we were told that nothing would change for Brits in the 27 because of the Vienna Convention, but that was never emerged. Does anyone have a comment? Chris? Vienna Convention and the law of treaty?
Well, there'll be many people on the panel who know more about the Vienna Convention than I do. Look, my kind of feeling about this is that all the way through this saga, there have been a series of what I would call kind of semi-digested factoids that were put out by Brexit supporters, of which this is one example, of which actually, the whole idea of trading on WTO terms was another one. But I think more particularly within that, then suddenly at some point in about, actually in 2017, I think, the first person I heard anyway to latch on, it was Jacob Rees-Mogg latching onto so-called GATT Article 24, and that this was this miraculous answer that would square all of the circles, or the way in which they latched onto the Carlson reports of the European Parliament that supposedly, gave this magical answer to the magical technological answer to the issues of the Irish border. And I think it was, I think these invocations of the Vienna Convention in relation to citizens' rights and so on, it was just part of the same thing. It was half understood. I don't think it was necessarily dishonesty. I think it was that these people believed that there must be a simple answer to these questions, and therefore there was a simple answer to these questions, and therefore when something presented itself, they pushed that as the simple answer to these questions. And of course, as soon as it actually meets, the realities, whether they're legal realities or economic realities or political realities or regulatory realities, they fall by the wayside. So I think it's just another example of that, is my understanding.
All right. Time is advancing, and each of these seminars, this is the biggest attendance we've had. Each of these seminars has been enhanced and maybe made more comforting. I'm not sure that's quite the right word. By a summation from my predecessor in office at the court, David Edward. Now I'd like David to try to cheer us up, perhaps, but from his appearance, he doesn't look exactly like Santa Claus. David.
Well, let me begin by reverting to Michael Russell and the Scottish position, because I think seen from Scotland, the problems are more acute. Seen from Scotland, the whole Brexit campaign was essentially a campaign of English nationalism. That the Scottish National Party are accused of being divisive nationalists, but the most divisive nationalists of all have been the Brexiteers in England. that said, the reason why Scotland, even for independence or not, the reason why the Scots find this whole idea of global Britain puzzling is because the Scots have a global outlook. There is an enormous Scottish diaspora. And we simply, I think, and I'm speaking for myself, but I think it is true, that the Scots just don't understand what more it is that one wants simply by uttering the mantra global Britain. On that issue, however, I remember the end of empire. And I remember it because at that time, 1955, 56, 57, I was doing national service in the Royal Navy. And in my training, I was on the lower deck, and when we entered Malta, the Grand Harbour in Malta, we were all lined up on the upper deck, and trumpets blew, and bands played, and guns were fired. Then we went from Malta to Suez. What for? To take troops from Suez to fight General Grievous in Cyprus. At that time, Malta and Cyprus were fully parts of the British Empire, and Suez was occupied by British troops. Then came the Suez adventure, and thereupon all the battleships and cruisers and everything that were lying in mothballs in Portsmouth Harbour were suddenly decommissioned and sent off to the breakers' yard. A number of our contemporaries who were regular officers were told there was no future for them in the Royal Navy. The whole thing suddenly collapsed. And the notion of the global Britain is some fanciful notion about the world which I actually saw, and I saw disappear. So that's my point of view, both from as a Scot and as somebody who is now significantly nearer 90 than 80. Going to the question of citizenship, I was the rapporteur, the judge rapporteur in the first two citizenship cases, Martinez Sala and another one called Gelschik. And they were the cases which raised the question, what did citizenship mean? And I remember with fondness the advocate for the French Republic getting up and telling us that when the citizenship provision was put into the treaty, it was put there in order to make people feel better, more enthusiastic about the union. But it was never intended that they should have any particular rights. And naturally, if you're told that the intention, if as a judge you're told that the intention of something is to deprive people of, or not to give people rights, the natural judicial question is, why shouldn't they give rights? I'm not going to speculate on the big question which is coming up that Jeremy Morgan spoke about. The only thing I'd say is that at that time, it was certainly said that European citizenship stemmed from being a national of a member state. And that's what I think is the hump that's got to be got over. Turning to Dominic Grieve and Chris Gray and the problems of Brexit. First of all, I think one of the tragedies about this is it's been discussed for a long time as if it was about freedom of movements of goods, trade. Now, goods do not fly across frontiers on magic carpets. They are driven by lorries, usually, the lorry drivers are persons, and they are employed by lorries, usually employed by lorry owners who are operating under the provisions of the treaty dealing with transport and providing services. And the deal for the purchase of goods was either made across the frontier or possibly by a salesman from in another country negotiating the sale of goods, possibly in a local subsidiary of the company wishing to sell the goods. That's provision of services and establishment. Once if the goods consist of complex machinery, they will probably be accompanied by a fitter or a technician who is a person crossing a frontier. And part of the service provided. And at the end of the day, who's going to pay for it and how are they going to pay for it? Because of the provision of the treaty dealing with capital, movement of money. All these things are comprehended in the single market. And it is simply nonsense to think that it's just about trade in goods. And it illustrates the fact of the comprehensive nature of the EU deal that we are now leaving. And whatever deal is made on or before the 31st of December cannot ever be as big as the deal that we had as full members of the EU. And that is a simple fact. It's not a matter of Ramona argument. I think it's one of the questions which was on the chat or the Q&A that we didn't get to was what happens about marriage, divorce, recognition of marriage, divorce, children. All these things were negotiated as part of the EU package. What happens if parties divorce and one is in one country and one is another? Which is entitled to have custody of the children? We negotiated all these things. They were all part of the EU package. And so whatever we get between now and the 31st of December cannot possibly, as a matter of fact, be anything near what we had before. So that is the consequence of Brexit, and that, I'm afraid, is why a number of people in Scotland consider that Scotland would be better off not pretending to be a global player, but being part of the EU system. I am still, I voted very firmly no in the referendum. I am now, I must say, ambivalent. I simply do not know what is in our best interests. But what is clear is that none of this is in the best interests of the British people.
Thank you. That wasn't very cheerful. We can't blame you for that. This is the fifth in a series and the best attended in a series. We were up 100 on stage, of discussions of the public policy questions presented by Brexit. I had guessed that by now it would all be over and that this would be a review of where we stand, but it's not all over. So Brexit was a political event that occurred on the 1st of February this year, but it is nonetheless also a process which is going to grind on for months and quite possibly years. And we don't know where it's going to end up.
Ian, can I just, as you look for a bit of cheerfulness, this was one of my birthday cards.
We can't see it, did we?
Stop thinking.
All right, but lawyers are paid to think. That's what pays for all these nice ties and books. So you can either follow the Edward birthday advice, which maybe isn't bad, or you can continue to think about these things. I guess there is a clear demand and support for these discussions of public policy. If people know someone who wants to speak in favour of Brexit, we really do look for them. They are extremely welcome. So please, if you know someone who wants to take a different viewpoint, please encourage them to get in touch. Let us, and we'll play that forward. We might have another one before Christmas, and if not, we'll be having discussions on public policy, possibly also questions on the subject of judicial independence and the role of Supreme Courts. That's quite colourful both in France and in England at the moment. And we might have a discussion about some of the interesting questions presented before. But for now, I would like very, very much thank the absent Michael Russell, the present Jeremy Morgan QC, Dominic Grieve QC, David Edward QC, and Chris Gray for their really excellent and, forgive the word, insightful analysis. We're very grateful to them, and I'm grateful to you, the participants, who have stuck with us to watch this. So I'll now close these proceedings, and thank you very much for your presence.
Thank you.